Hi, my name is Jeff Dillman, and I'm the co-director of the Fair Housing Project of Legal Aid of North Carolina. And today we're going to be talking about strategies to address homelessness using the Fair Housing Act. Before we get into the presentation, I do want to encourage people to, if you have any questions, to please put those in the chat box. We'll be answering questions during a roundtable discussion at the end of this presentation. But I do want this to be as informative for folks as possible. And I do really want to encourage people to put any questions they do have in the box. And we will hopefully be able to open it up later as well for people if they have questions that come up during the question period, the roundtable period. I also do want to note that this presentation is for information purposes only, and so I can't give any legal advice during today's session. So we're going to be talking about homelessness and ways that the Fair Housing Act can be used to try to help individuals who are homeless or have a history of homelessness obtain and maintain housing. And I want to talk initially about some certain aspects of the homeless population. The homeless population in some ways is so large in this country that there's people of all different types of groups that are homeless, but there are certain aspects that I do want to highlight. One is that there is a higher degree of people with disabilities who are homeless. And so, in fact, the federal definition of chronic homelessness is a person with a disability who experiences extended or repeated episodes of homelessness. And some statistics here from 2016 of people who were in permanent supportive housing, 73% had a mental health disorder, 27% had a physical disability, and over 6% had a developmental disability. In addition, there's a it goes both ways, a sort of circular relationship between homelessness and incarceration. And so having been incarcerated does lead to increased homelessness. And so the people are 13 times more likely to experience homelessness, people who've been incarcerated more than once, than the general population. And so if an individual has been arrested, and in particular multiple times, that leads to increased homelessness. And in addition, in that circular aspect that I was talking about, people who are homeless, who are unsheltered in particular, are more likely to interact with the criminal justice system than people in shelters. And so there's a 10 times greater incidence of police contacts. There's increased twice as many ER visits, 3 times more ambulance rides, and a much greater incidence of people going into jail. So you have among the homeless population, people who have had more interactions with criminal justice system, and that leads to increased problems with regard to being able to find a place to live. Finally, one other thing I'm going to point out is in particular among youth homeless, is that there are an estimated 20 to 40% of homeless youth are LGBT, according in a 2011 survey of transgender individuals found that a large percentage of these individuals were either denied a house or an apartment because of their transgender status. They were evicted because of their status. A number of people are thrown out of their houses by their families when their families discover that they are transgender, or even that they're lesbian or gay. So, and then finally, in even accessing homeless shelters, there is a higher incidence of transgender individuals being turned away or forced to stay in a shelter that's designed for the wrong gender, not the gender they identify with. And then there's high rates of harassment and even assault by both residents and staff of shelters. And so we're going to be talking about ways that the Fair Housing Act can help people in several of these communities in addressing their situation and trying again to find and maintain housing. And when we look at homelessness in the state of South Carolina, this is just a snapshot of where it is in 2018, but there were almost 4,000 individuals experiencing homelessness, and that chronically homeless, which are all people with disabilities, is 686 at that time. And you can see here, there's a range of individuals, they're of all races, and of the homeless individuals, about 2/3 of them were in shelters, 1/3 being unsheltered. So the Fair Housing Act was passed in 1968, and it broadly applies to what are called dwellings, places where people live. And so this includes not only single and multi-family housing, like houses or apartments or condominiums, but it also includes group homes, and they could be homes that are for people with recovering from substance abuse disorders. It could be group homes for people with disabilities or for some other reason. It includes most shelters, domestic violence shelters, as well as many and most homeless shelters. It includes places where people are living in groups like assisted living or migrant housing, people who might work in agriculture. And then what's called long-term transient lodging. So not a hotel or a motel where someone might go for a weekend or even a week or two, but somewhere where someone is staying for an extended period of time. It might be one of those extended stay hotels, but they're staying there for several months or more. So all of those types of facilities, those types of places where people are staying, would be considered dwellings, and the Fair Housing Act would apply to those types of properties. And the Act is very broad in terms of who has to comply with it, and so it's virtually anyone who's involved in renting or selling or managing property. So in a rental context, it's the owner or landlord, it's the manager and the management company and all the employees of that company. If someone were purchasing property, and I realize that's much less often with regard to someone who might have been homeless, but it would be anyone who's involved in the sale of the property. So the agent and the companies, the seller, the lender, insurance companies. And then it also does include things like homeowners associations and condo boards. And a lot of times they don't quite understand that their obligations extend to individuals who are either owners of a condominium or a property in a homeowners association, or renting from the owner of that property. And those individuals residing there do have rights. The groups that are protected from discrimination, and we're going to start focusing in a little bit on several of these in particular, but it includes, it prohibits discrimination based on someone's race, their color, their national origin, religion, their sex or gender, and we're going to talk a bit about gender discrimination in a little while, their familial status, so whether they have families with kids, or their disability. And the Act is very broad, and so it prohibits discrimination, for example, based on anyone's race, whether they're African American or whether they're Asian American or white, based on any religion, so whether they're Christian, whether they're Jewish, Muslim, or atheist. So the Act is very broad in terms of protecting discrimination. And now I want to turn and focus a bit on some of those areas that I identified at the very beginning in terms of individuals who are homeless might have higher incidences of certain types of memberships in these protected classes. And the first one I want to focus on is disability. And the definition of a disability under the Fair Housing Act is someone who has a physical or a mental impairment that substantially limits one or more major life activity. So it can be something physical. They might have, they could be blind or have some other sensory impairment. They could have a mobility impairment, or it could be a mental illness or a developmental disability. But it's one of those things, a physical or mental impairment that substantially limits one or more major life activity. The major life activity could be anything from walking or eating or caring for oneself or learning, ambulating. So there's a wide variety of different types of activities. It also covers someone who has a history of an impairment. So they might not currently be unable to do anything, but in the past they were. And finally, someone who's perceived as having an impairment. So they might not have any limitations at all, but just because of the way they walk or they talk or the way they appear, people assume that they might have some limitations and treat them differently. And these, while most fair housing cases tend to involve the first option there, someone who actually does have a physical or mental impairment, these other two become very important with regard to certain groups. And I think that among the homeless population, that sometimes having that history of an impairment or being perceived as having impairment could also come into play more commonly than among certain other populations. Finally, I just wanted to point out that people that are associated with someone with a disability are also protected. So it might not be the person signing the lease, but it might be their spouse or partner or child. And that whole family unit would be protected from discrimination. And so I gave some examples of these types of disabilities a moment ago, but sensory impairments are considered disabilities, mobility impairments, mental illness, cognitive disabilities, HIV positive status. Alcoholism is a disability under the Fair Housing Act, and former drug abuse, not current drug abuse. And there is actually an exception. People who are currently abusing unlawful drugs are prohibited, or they're not covered by the Fair Housing Act. But someone who formerly used unlawful drugs and has been through treatment, is no longer using them, can't be treated differently just because of their status as a former drug abuser. So what does the Fair Housing Act say with regard to people who have a disability? First of all, you can't discriminate against them. A landlord or a shelter owner or manager or someone else in those categories that I talked about earlier, that are people that are obligated to follow the Fair Housing Act, they can't treat someone differently. They can't refuse to rent to someone because they have a mental illness, or their spouse or their child has a developmental disability. They can't charge them more rent because of one of those, because of a disability or any other protected category. So treating someone differently, discriminating against someone because of their disability is unlawful. And with regard to disability, there's a few sections that we're going to talk about that are broader than the rest of the Fair Housing Act. And one of them, the first one, is that housing providers are not allowed to ask questions about the nature or existence of someone's disability. So they can't ask a prospective tenant, for example, why do you get SSI or SSDI, which are two types of disability payments. They can't ask, do you have any disabilities? Do you take any medication? For most general types of housing, any kinds of inquiries into the nature or existence of a disability are prohibited. Now, there's a couple of exceptions that I'll point out. First is if you have housing designed for people with a particular disability, then a provider there could ask questions about that particular disability, but shouldn't ask questions about any other one. So HOPWA is a program designed for people with AIDS or who are HIV positive. And so if you have HOPWA housing, the provider can make sure that people are HIV positive, but then they couldn't ask about whether they have a mental illness or some other type of disability, a mobility impairment. Also, certain types of HUD housing, providers are required by HUD to collect demographic information. So they may be required to ask about someone's disability so that they can report that to HUD. But for most private housing, inquiries, questions about someone's the existence of their disability, whether they have one or what it is, how severe or anything else about that are prohibited. Now, in addition to that provision about inquiries, there are two other important areas under the Fair Housing Act disability protections that give people with disabilities additional rights in terms of what they may be able to do. And these are especially important for people with disabilities because if you think about the Fair Housing Act, most people think about the act as trying to treat everyone equally. You don't want to have differences between how one person is treated and another person is treated. And for much of the Fair Housing Act, this is true. We do want to see people being treated the same. But with regard to people with disabilities, treating everyone identically doesn't necessarily lead to a fair result. And so this is, if you think about this, if you think about someone who might be blind or who has some other sensory impairment, and you were to say, well, we're going to treat everyone identically, they have to fill out this written application. Someone who has a visual impairment may not be able to do that by themselves. And so just saying they're going to treat everyone the same doesn't lead to a fair result for that person. And so under the Fair Housing Act, there are two provisions that are especially important for people with disabilities that allow them to make changes, to ask for changes in what rules and other things are in the housing that allow them to have that fair opportunity to reside there. And the first one we're going to talk about is what's called a reasonable accommodation. A reasonable accommodation is a change in a rule or a policy or a procedure that's necessary for a person with a disability to be able to fully use and enjoy the dwelling, the housing. And so an example could be that, say, an apartment complex normally has a rule that in order to rent there, someone has to show up in person and go to the leasing office and apply, submit the application there. Well, what if someone has a mobility impairment? They can't, they're in a wheelchair, and the leasing office is up a flight of stairs. There's no elevator. Well, that person with a mobility impairment doesn't have an opportunity to even get into the leasing office to be able to apply to rent there. And so they could ask for a change in that rule or that policy and say that their social worker or their caseworker or their friend or brother is going to come and pick up the application and then submit it. So the person doesn't have to go into the office on their own. So that's a change in a rule that's necessary for that person because of their disability to be able to fully use and enjoy the dwelling. And you can ask for a change in virtually any type of rule or policy, again, if it's necessary because of a person's disability to be able to use or enjoy that dwelling. You can ask for it when you're applying, before the tenancy starts. You can ask for it during the tenancy. Even when someone's facing eviction, they can ask for an accommodation if what the accommodation would do would be to remove the reason for the eviction. So for example, we sometimes have clients who, because of their disabilities, wind up hoarding. They've got a lot of stuff in their unit. They might have stacks and stacks of old mail or newspapers or magazines or other personal effects. And the housing provider notices it, maybe they're doing an annual inspection, or maybe the maintenance person was in doing some work, and they ask the person to remove it because they say it's a health and safety issue. So that's fine so far, but the person is unable to get rid of that in the time required. Maybe the landlord gave them 30 days to come into compliance. And so they're facing eviction for non-compliance with that. They could even at that point file or request a reasonable accommodation. Not that they get to keep all of their stuff indefinitely, but they get some additional time to come into compliance. If the reason they're unable to comply to clean out their unit in that 30-day period is that is related to their disability, and oftentimes it's related to a mental disability. Sometimes there's a physical component as well, but often it's a mental disability. They could ask for an additional 60 or 90 days to come into compliance. So it's not that they get to keep everything indefinitely, but just they get some extra time. And that could be a defense to an eviction action if they're facing that. So again, an accommodation is a change in a rule or a policy or a procedure necessary for a person with a disability to be able to fully use and enjoy the dwelling. Now, an accommodation request can be denied by a landlord or a manager in two main situations. One is if it would require a fundamental alteration in the nature of the services that are being provided. So if a tenant, say had a dog and became disabled and could no longer walk the dog, most landlords aren't engaged in dog walking businesses, and so the landlord doesn't have to start walking the tenant's dog for him or her. just because the person has a disability and can no longer do it by himself. The second way that or reason that a landlord can use to deny a request for an accommodation would be if it creates an undue financial and administrative burden. So a tenant could not request to lower the rent, for example, because their disability payment isn't as high as what their employment income might have been, right? Or they can't request something else that's going to be overly expensive. Now, there might be some costs associated with an accommodation. Someone's accommodation could, for example, be that they need to have a reserved parking space. And so the landlord is going to have to put up some signs, maybe paint the asphalt to note that this is going to be a reserved space for a particular unit. So there might be some expenses, but it can't be an excessive, an undue amount of financial and administrative burden on the landlord. And so I'm not going to go through all of these, but some types of examples of accommodations that we see somewhat commonly are, for example, the rent might normally be due on the first of the month, but if someone, their sole source of income is a disability payment, then they could ask that the rent due date be changed to coincide with when they get their disability payment, because that doesn't always come on the first of the month. And so it might come on the 10th or the 15th. And so they could ask to move the rent due date, not to pay less rent, but to move the rent due date. Or maybe they need to move from the second floor of a building to the first floor because they have a mobility impairment and they can no longer go up the stairs. So they can ask for that and not have to pay a fee that sometimes landlords might charge for changing from one unit to another. Other times people might need to add an extra occupant to the lease to have a live-in aid, even though that person wasn't on the lease to begin with. I mentioned earlier, a rule of terminating tenancy due to poor housekeeping, and someone could get more time to remove excess clutter. In the opposite direction, someone might need to terminate a lease early because of their disability. Maybe they no longer are able to access the property, either because of a physical disability or they can no longer care for themselves and it's not big enough to allow an aide to reside there. So they could also ask for an early lease termination. Assistance animals and service animals are another type of accommodation, and this has generated a lot of news and a lot of concern among some landlords. And so I do want to speak for a minute about this in particular. So landlords are allowed to have any kind of rules they want for a pet. And so they can prohibit pets, or they can have limits on what types of animals, no dogs, or no dogs above a certain weight, or limits on what breeds of dogs might be allowed, charge extra rent. All of those types of things are fine for pets. But if someone has a disability, and because of that disability has a service animal or an assistance animal, that animal is not considered a pet. And so those pet rules don't apply. And so even if a landlord normally said no dogs above 50 pounds and no vicious breeds, if I had a disability, and because of my disability had a 65-pound pit bull, that animal would be allowed to reside with me in my unit. Now, if my particular pit bull was aggressive, the landlord could keep that animal out, but he couldn't keep out the animal just because of its breed. Really briefly, there's differences in the law between a service animal, which has to be a dog or sometimes a miniature horse that's trained for a specific task, and a broader category, which is called an assistance animal. And an assistance animal doesn't need individual training. It doesn't have to be a dog or a miniature horse. It can be a cat, or it can be a turtle, or it can be a bird, a small bird, something like that. Most assistance animals are the kind of animals that people normally keep in their household, and most of them are dogs or cats, but sometimes they're different animals. Very occasionally, people have what HUD has recently started calling unique animals, animals that aren't traditionally household animals, maybe a farm type animal, a chicken or a pig or something like that. And those types of animals, it's much more difficult to be able to make a request to keep that type of animal. You would have to make a strong showing of why why a dog or a more traditional animal wouldn't be sufficient, and there would be limits on type of property where those types of animals would be allowed. But in general, under the Fair Housing Act, someone who has a disability, who needs either an assistance animal or a service animal, would be allowed to have that animal if it's one of those commonly kept household type animals. And if there are questions, specific questions about assistance animals or service animals, I'm happy to, again, please put those in the chat box, and we can discuss those during the roundtable section in just a moment. Now, the accommodations that we've been talking about are changes in rules and policies and procedures, but there's another type of change that someone with a disability can also ask for, and these are called reasonable modifications. And a modification is a change in the physical structure of the property. So it's again not a rule change, but it's an accessibility modification, generally for someone with a physical disability, although it doesn't have to be. People can request and make changes to the inside of their own units or to common areas. So it might be something in the bathroom that they need changed, or it might be something going down to the laundry room that they need changed. If they make changes to the inside of their unit when they leave, if it's reasonable, they can be asked to return it to its original condition. But if it's changes to the common areas, they don't have to return those to its original condition when they leave. Now, modifications can sometimes be expensive because these are physical, structural changes to the property. And in private housing, the modification is made at the tenant's own expense. So the tenant either has to pay for it, him or herself, or they have to find someone or some agency to pay for it. The landlord does not have to pay for it. And private housing includes not only market rate housing, but someone who's using a Section 8 or some other tenant-based voucher, a VASH voucher that's designed for veterans, or a voucher that's for people with disabilities, or sometimes there's vouchers for people who are homeless or recently been homeless. So those are still considered private housing if there's no other additional subsidy that the property owner is getting. And even tax credit properties, properties that are funded through the low-income housing tax credit program are considered private unless they also receive some other type of HUD funding. So where the provider has to pay for it is where it's HUD funded housing. So it might be owned and paid for by the Public Housing Authority, or it might be what's called project-based Section 8. So it's not a voucher, but the building itself is subsidized for whoever winds up residing there, or other housing that's funded with HUD money. It could be money from, and HUD has a whole range of programs, HOME and ESG and HOPWA, COC, the Continuum of Care. If it's funded with some of that money, then the housing provider would have to pay for the modification if it's reasonable to do so. And so the kinds of changes people can ask for are really any type of modification that would allow them to fully use and enjoy the dwelling. So it might be as simple as a grab bar in the bathroom, in the shower area, or next to the toilet, or wherever the person may need it. It could be changing the heights of light switches or thermostats. It could be changing door handles from knobs to lever handles. Or it could be more extensive modifications, widening doorways, putting in wheelchair ramps, installing different fixtures in a bathroom or a kitchen. So it could be, again, a whole range of types of changes. But again, for private housing, the individual, the tenant would be responsible for making these changes. And for public housing that's funded by HUD money, then the provider would have to do it unless it's unreasonable for them to do so. There are a couple of exceptions for who is entitled to protection under the Fair Housing Act. And so the first one I do want to mention is someone whose tenancy would pose a direct threat to the health or safety of other people, or their tenancy could result in substantial property damage. Now, if a landlord is trying to keep someone out because of those reasons, they have to make that determination on an individualized basis. They can't just assume that because someone appears a certain way, or even because if the landlord learns that this person may have a disability, they can't use the mere fact that someone has a disability to say that they have that they would pose a direct threat. So it has to be an individualized determination, because we know that most people with disabilities are not dangerous. They're not more likely to cause damage. Even most people with mental disabilities and say schizophrenia are not necessarily, they're not more likely to, or they're not inherently, because of that diagnosis, likely to be a danger. Now, some individuals who do have disabilities are going to be dangerous. Some individuals without disabilities are going to be dangerous. And what the Fair Housing Act says is that the provider has to actually make a determination. Does this person, not because of their disability, but does this person specifically pose this type of danger? Also, sometimes someone may in the past have been a danger. They may have had untreated mental illness, and may not now. And so someone, if they had a history of dangerous behavior, and that history was based on a disability, and the person has since gotten into treatment and no longer poses a danger, they could ask for an accommodation to not be kept out because of that past history. If again, they can make that showing that they're no longer a danger. And I mentioned earlier before that someone who's currently using illegal drugs is excluded from the definition of a disability. So if someone's a prior user, a former user, and has been through treatment and is no longer using unlawful drugs, they can't be kept out, treated differently, discriminated against because of that status as a former drug abuser. But if they are still currently using them, then they are not entitled to the protections of the Fair Housing Act. So I really briefly want to raise a couple of issues before we end here about tenant selection and criminal history screening. And this is very important because the Fair Housing Act doesn't explicitly mention criminal history as a protected class. But as I mentioned at the beginning, people who are homeless are more likely to have been arrested. And if you've been arrested or spent time in jail or prison, you're more likely to wind up being homeless. It's more difficult to find housing. And so about 5 or 6 years ago, HUD issued some guidance about how criminal history screening could implicate the Fair Housing Act. And the first thing that they noted is that arrests are not a showing or not a determination that someone has done anything wrong. And so housing providers should not be making decisions based on someone's past arrests if there's not a conviction. To do so could potentially be a fair housing violation. And the reason is because although whites and blacks, for example, commit most crimes at very similar rates, if you're Black, you're much more likely to be arrested and be convicted and to be sentenced for a longer period of time. And so if a landlord is using criminal history as a screening tool, they're more likely to screen out Blacks and as well as Latinos and some other groups than they would whites. And so housing providers, HUD has said, should not be using a mere arrest without a conviction as a tool for screening people out. Now, if someone has been convicted of a crime, that can be used if it's used carefully. A blanket prohibition on anyone who's been convicted of a crime would not be permissible. So a landlord couldn't say no convictions or even no felonies. But a provider could use criminal convictions as a basis for making decisions if they have a tailored policy that looks at things such as the nature of the offense that someone was convicted of, how severe it was, and the amount of time that had passed since the conviction or since the conduct. So, treating someone who has very recently been convicted of a violent felony, maybe that person should be kept out. They might be a danger, but if someone has an offense from a number of years ago, or it's a lower level offense, it's a misdemeanor or a mere infraction, and it's nonviolent, then that should be treated differently. And I think that makes a lot of sense to most people. So treating convictions or using convictions is permissible as long as it's done in a tailored way that considers, the context of the criminal conviction. In addition, if a landlord is screening people based on criminal history and just, again, only using their convictions, they have to screen people the same. So if they're screening everyone, they can't only screen people, or they need to screen everyone. They can't only screen people who look suspicious. They have to, when they're screening them all, they have to treat them the same. So if someone is Latino and they're kept out for a violent felony last year, then other people in other groups should be kept out for a similar violent felony that occurred last year. They can't be using the criminal history as a pretext for discriminating based on race or some other protected category. And finally, I do want to point out that sometimes criminal history is related to a disability. And so a tenant might have been convicted of a crime that related to a disability. It could be a public intoxication offense, or it could be a disturbing the peace offense, or some other type of offense. And so someone who has that conviction that relates to their disability could ask for an accommodation to not have that be used to keep them out, even if it's a more recent one. And there was a case out of Virginia not too long ago where someone was convicted of indecent exposure that was related to their disability that occurred within the last year. And they got into treatment and were able to show that they were unlikely to reoffend. And the court ruled that the provider should have granted an accommodation in that case and not kept the person out, because they had shown that the conviction, again, was related to the disability and that their disability was now controlled and they were unlikely to reoffend. So I've run out of time here for this part, and I hope to, when we get into the roundtable, talk a little bit about sex discrimination and LGBTQ status. So we'll pick that up from there. And again, if you do have questions, please put those in the chat and we can have a discussion with those later on. So thank you very much.